Good afternoon, and thank you for coming to give evidence to us this afternoon. Perhaps you could just go down the table and say who you are and the organisation you're here representing.
Dr. David Smith, I'm the Policy Director for the Residential Landlords Association.
Adrian Jenkins, I'm the newly appointed Chairman of the NLA, National Landlords Association.
David Smith-Milne from a company called Place First. We're a residential landlord, and we specifically build houses for market rent.
Okay. Thank you, all of you, for coming this afternoon to be with us. You probably heard in our previous session information about the minority of properties which have got problems in terms of their fitness, tenant dissatisfaction with the minority of properties, and also over a quarter of properties don't meet the decent home standard in the private sector. Why do you think it is that we've got this minority of properties and probably minority of landlords who simply don't provide housing of an acceptable standard?
It's important to be clear that it is a minority and it is slowly decreasing, but it doesn't matter for the people who are living there. One property, in a sense, is one too many, but our perception is, in part, that there are a number of properties that are good, and that's an increasing number, but the properties that are bad are very bad and increasingly worse. And that seems to be caused partly by age of housing stock. The housing stock, particularly in the PRS, is exceptionally old. It was never intended to be around as long as it has been. And that's been complicated by a range of factors. But it remains the case that enforcement activity is not working. We've looked at freedom of information data, and someone earlier referred to this as a postcode lottery. I don't think it's a postcode lottery, because a lottery implies you might win occasionally. The reality is that local housing authorities, in terms of enforcement activity, you can point to maybe 5 or 6 that are aggressively and actively enforcing, and after that the numbers just die. And in fact, those 5 or 6, really, you're talking the majority is 2, one of which is the previously mentioned Newham. If you take Newham and Barking and Dagenham out of the figures, because they skew the figures, only 1 in 2 HHSRS complaints are picked up, half. If you go and look at local authorities that have blanket licensing schemes, it's actually worse. It's 1 in 3, which is almost counterintuitive. You would expect it to be more, but it's not. So the reality is, at the moment, that there is nowhere near enough enforcement, and it's extremely patchy and uncoordinated. And frequently, enforcement from our perspective is actually aimed at people whose head appears above the parapet, rather than necessarily the very worst landlords, who are becoming increasingly adept at staying well below the parapet and swimming further and further into the bottom of the mire.
Well, that was fairly comprehensive. I'm a little bit of detail to it. First of all, the decent home standard, I believe, was not designed to apply to the PRS. It was actually for social housing. We have the HHSRS and hopefully the Fitness for Human Habitation bill coming up, which we support. The larger proportion of older properties in the PRS, for example, 34% were built before 1919. Only 6% of social housing was before 1919, and that brings issues with it. The percentage has fallen. It is improving, including energy efficiency. And it's probably worth pointing out as well that despite the figure for missing this number, private renters are slightly more satisfied than those in social housing, which have a higher achievement on this particular scale. But it all comes back to, as David has said, to enforcement, and there doesn't appear to be enough enforcement going on.
Is that resources or willingness?
You'd have to ask the local authority that, but I suspect they'd say resources.
I find my other hat on as a lawyer, I do a large amount of consultation work with environmental health officers and speak to them a lot. I tend to find it's actually a mixture of 3 things. The legislation is too patchy and complicated, and there's far too much of it cross-cutting. And so many environmental health officers have trouble understanding what their powers actually are and find it difficult to use in practice. CLG has done some work around providing best practice guides to local authorities, but could do a lot more in this area. The second is resources. Sure, money's always a problem. But the third issue as well is local political will. Not every local authority is really prepared to commit aggressively to this area, which is unfortunate. Again, one of the reasons people talk a lot about Newham, I find Newham's often mentioned in a licensing context, but the reason Newham's not a very good example to use everywhere else, I constantly find myself speaking to HOs, and someone from Newham's always there, and so everyone goes, let's be more like Newham. But Newham has spent a fortune on housing standards and have created a proper cross-agency approach. Now, if every local authority did that, that would be great. But the reality is that most local authorities want to do what Newham are doing, but without doing all the really, really hard work that Newham had to do to make that happen. And it's important to bear in mind that there's a huge amount of effort gone on in Newham in terms of bringing in immigration, the police, HMRC, and their TROs, and building proper policies and putting a vast level of effort into really tackling these issues. And unless every local authority wants to do that, simply throwing money at it isn't enough.
Yes, please.
I think the issues quite fundamentally relate to the ease with which one can become a landlord. It's still the case, despite previous government intervention into encouraging institutional interest in the private rented sector, that the vast majority of people living in privately rented accommodation are renting ostensibly from amateur landlords. And as a consequence of that, individual tenants are renting from a small-scale investor who maybe has one or two properties within their portfolio, but because of that lack any fundamental infrastructure, lack anything that gives the tenant real long-term certainty about their tenancy and their right to remain within the property, and a very highly variable attitude towards quality and safety. And I think the single biggest thing the government can do to address some of these problems is to encourage much more institutional interest in creating properly and appropriately managed neighbourhoods for private rental tenants. Now, but the instruments that are historically being used to encourage and facilitate that have ostensibly been financial, where I think government have offered various bond and guarantee schemes to encourage more institutional capital into the marketplace. And as a kind of adrenaline shot at the very beginning of the whole ascendancy of certainly institutional private rented sector, that was very valuable and very worthwhile. But actually the sector's evolved very, very quickly. And actually there's no shortage of capital whatsoever trying to find itself into the private rented sector in one form or another. And we've heard today, and we see every day in the press, there's no shortage of demand for the actual housing stock. So the fundamental things that can be done to address the sort of landlord-tenant imbalance is to actually create an environment within which it makes total business sense to treat your customer as sacrosanct, as the most important person within the transactional environment that you operate in, which is what we as a business do. So our total focus is on end-user experience. We don't charge fees, we don't charge any costs whatsoever to the tenant other than the monthly rent. And we can come on to some of the issues with the proposed bill later on, no doubt. But in my view, if government's to try and improve quality, then it needs to almost improve the kind of wider economic levers which encourage more organisations that operate at institutional scale with a total focus on end-user experience to become active in this market. And that's as much about land as it is about landlord-tenant relationship and the dynamic of the law in that respect.
I'd like to briefly disagree with characterisation as professional landlord as being good and amateur landlord as being, by definition, bad. That's not supported by the facts. And the reality is that professional investors, undoubtedly, I'm not criticising my near namesake here, I'm sure they are a very good professional landlord. There are also very bad professional landlords and very bad institutional landlords. And bad institutional landlords are in a sense worse because they've got more tenants suffering under them. So there's an aspect, and indeed institutional landlords across the whole of Europe don't take up more than 50% of any substantive market in Europe. So even if the government was to do as well as every other European country, they would achieve 50% professional landlords. That's not going to radically alter the dynamic. Simply saying that more professional landlords will improve the position of tenants is completely unsupported by any evidence.
Well, sorry, I don't want to get drawn too far into that debate, but the issue is an absence of quality, of competition at that level right now. There are a number of very poor institutional landlords, and I totally agree with that point. And yes, you're right, just because you're a corporate body doesn't necessarily mean that your customer service and standards are necessarily going to be any better than a very well-meaning amateur landlord. But there is still a very limited amount of competition within the professional landlord sector, and the more competition we can encourage, the more ultimately I think we'll see an improvement in standards.
Karen Brooks' bill was mentioned with support. Is there anything that could be done to improve the bill that you'd have? Yeah. If not, if you're dissatisfied with that,
our biggest ask would be for a proper specialist housing court, preferably modelled along the line of the existing first-tier tribunal. It's been rightly pointed out that tenants have a fear of going to court. Completely agree. So do landlords in practice. The first-tier tribunal is a cost-free jurisdiction, so it removes the fear of losing cost. It also has its own inbuilt specialists, so you don't need to wheel in your own personal HHSRS expert to prove your case. We think that would go a long way towards making the system work better for tenants. Inevitably, of course, we would want all housing jurisdiction moved into the single tribunal, so we think it would be productive for landlords as well. And I'm aware that the Minister has already committed to that, Secretary of State has committed to that, so I won't belabor the point for you.
That's great. Okay, fine. Mark.
Thank you. In looking at the current regulatory framework, it's been put to us that there are over 400 regulations today in 145 separate pieces of legislation, which you and your members need to abide by at the moment in England and Wales. Is that regime fit for purpose? Mr. Smith talked about the enforcement end, but the regime itself, regulations, is it fit for purpose, and what needs to change?
No, we think it's very patchy. I think those figures are ones that my organisation has trotted out a few times, because there are lots of pieces of legislation that don't have statutory instruments enacted under them that could make them operate effectively. We've talked about tenant fees. The Consumer Rights Act has provisions already within it for the Secretary of State to pass regulations to require agents to more clearly specify what their fees are charged for to improve transparency. That would have an immediate on-the-ground benefit as opposed to a draft bill that's not even been laid before Parliament as a body yet, which is therefore quite a long way off. The How to Rent Guide is now produced by regulation. It exists. It was revised this week. It was revised this week to remove reference to London rental standard. That's the only revision that was made to it. That doesn't advance the position of landlords or tenants at all. All landlords now have to go and change their procedures and make sure they're giving the right guide to tenants, which causes a lot of time, energy and effort across the sector. But it doesn't, for example, mention the Homelessness Reduction Act. It doesn't in any way detail mention retaliatory eviction powers. So it doesn't cover a huge range of things which that could do. A lot of the legislation is very old. Karen Buck's proposed bill that's now been taken up by the government is a good example. That bill shouldn't have been necessary because the legislation already existed. It just hasn't been revised, actually, since it was first introduced in the 1880s. So there's a lot of situations where we've got very old legislation sitting on the statute books. I still regularly talk about the Distress for Rent Act, which was passed in 1780. So we're sitting with ancient legislation on the statute books. We've lumped on more on top without properly thinking about how it links into what already exists, how what exists could be made to work more effectively, and then how we tie that patchwork together. And if you go and look at what's happening, much as I don't want to go on about devolved assemblies here, the Welsh government's tried to replace a whole patchwork of legislation with the Renting Homes Wales Act. It's actually going wrong for them to some extent because they're having so much trouble working out all the different bits and bobs they need to repeal and amend to make it work because it's taken so long. And unlike the Finance Acts or the Companies Acts, where we've dumped the whole system and started again and reenacted, there's a real reluctance to do that across what is a rather patchwork system. Yeah, it's good for lawyers. I hasten to add.
Yes, Mr. Smith-Milne.
I think as a landlord, or speaking as a landlord, we tend not to interface particularly with the legislation because we take our role and the level of responsibility inherent within that role very seriously. But I do agree with what David said. I mean, we are now seeing a reasonably seismic shift in tenure patterns in this country, with private renting now overtaking social renting for the first time in a generation, and that's unlikely to change. It's unlikely to reverse in the immediate term, and we have a fundamental requirement in my view, and I agree with David, to fundamentally look at the legislation rather than to pass bills or component parts of legislation which interface and interplay with a whole patchwork of other things. And I think actually we now have, behind 1 in every 4 front doors is a family renting their house from a private landlord. That's a huge proportion of the population. I think that necessitates a more fundamental and thorough look at the legislative environment.
Well, tinkering always produces perverse outcomes, as well as occasionally producing the outcome you wanted. It's a humongous task to rework all of this, and we don't really know whether it works that well or not, because time and time again people have asked for comprehensive reviews of licensing schemes, for example, and they've not been done, so we don't know whether that bit of the law works or not. It does seem that in some places enforcement works if it's properly resourced, but again there are questions around that. So yeah, it's complex, it's probably too complex, but I wouldn't rush into changing it.
You'd stick with where you are at the moment?
Well, if we could get some stability.
Right, okay.
Because everything is moving all the time at the moment.
Okay. Good.
And that makes it harder for people to be good landlords in turn, obviously.
Yeah, no, I understand. Thank you. Bob?
Yes, turning to, you may have heard the exchanges earlier about the licensing agreements. You seem to be quite sceptical, to put it mildly, about the selective licensing agreements. Can you explain to the committee why you oppose them?
The RLA supports targeted specific licensing, but doesn't support blanket local authority licensing across their entire area of responsibility. There is some evidence that targeted specific licensing in hotspots is effective, in part because it tends to break up tenant ghettos and spread tenants out across the whole area, which sounds like a bad thing in some ways, but actually in a sense it's more productive, because having areas which become predominantly tenanted is bad for social cohesion. There is no substantive evidence that licensing does anything better than get people to have licenses. And the danger with licensing schemes is they become Al Capone-like in their nature, in that you can't get landlords for having poor quality property, so you fabricate something else with which to get them. Now, in practice, that worked. Al Capone went to jail, hurrah! But it doesn't.
He went to jail for tax evasion.
Well, quite. He went to jail, but he did go to jail, and that's the important, possibly the important point here. But I don't think it does a lot in terms of improving standards, and to some extent, I think some of the biggest proponents of licensing have tacitly admitted that. Newham has asked for its licence to be renewed. In renewing that, they said they had now felt they had licensed most landlords, although at the same time they also, of course, said that 25% of them aren't paying tax, and they haven't managed to do much about that. But they also said they haven't resolved housing standards in 5 years, so quite clearly there is still a problem with housing standards. I understood the objective was to sort out housing standards, not to give people pieces of paper. Now there are other justifications for licensing, but to my mind the objective is to give everyone a decent home to live in. I'm not convinced that blanket licensing schemes necessarily achieve that.
Well, the fees are often high. Good landlords often end up paying for the poor ones, which doesn't seem fair. Beyond that, again, there hasn't been a comprehensive review, so do they work or not? The jury is out. They can't. Sorry.
This was pointing out the more tightly focused schemes in particular areas could be advantageous.
They may be, yes.
I think there is one academic study that suggests that they do that for the reasons I've outlined.
Yes,
but it's very hard to build evidence.
But there's no evidence yet of them having an effect on the quality of housing, which is the key, as you said.
There's also a risk of unintended consequences.
Right.
Higher rent, shorter tenancies, less properties available to vulnerable groups, etc.
You also end up with evasion structures. I've had plenty of landlords phoning me up asking how they can become for-profit housing associations, because for-profit housing associations are exempt from licensing. There's certainly an aspect in which some for-profit housing associations that have sprung up are simply there to bypass licensing.
We operate within a tightly defined licensing area with one of our projects, and I totally agree. There's been no evaluative evidence as to whether or not it's been successful. Irritatingly, it's been renewed, and in its 5 years of operation, it's cost us a considerable sum of money, which initially we didn't mind paying for, because you could see the quality of private rented property in the immediate vicinity needed substantial improvement. But throughout its lifetime, there have been 9 convictions under the scheme, but they were all for not being licensed. And only 1/3 of the entire stock of properties within the licensing scheme have actually been surveyed. And without any evaluative evidence, that scheme's been renewed. And for us, we've seen no discernible improvement in the behaviour and standards of other private landlords in the neighbourhood. In fact, we've seen almost a perverse subsidy arrangement whereby our fee has contributed to free things for other landlords, including free smoke detectors, carbon monoxide detectors and everything else. And we've worked especially hard to regenerate housing stock in this neighbourhood, create very high quality homes for families to rent, create public play facilities, parks, all of which we maintain and everything. And actually what we've seen in the immediate vicinity is not an improvement in comparable property stock. We've actually seen more of a race to the bottom amongst some of the worst landlords, who are now actively targeting households with serious social problems, addiction problems and all sorts of issues. And there's been on the way here today, actually, I thought I'll just see, how many evaluations can we discover of the effectiveness and performance of these schemes, because the KPIs are actually relatively straightforward to define and measure, and I think that the lack of evaluative evidence is a real concern.
Even in that evidence we just heard, that local authority concern has 2 breaches of statutory duty. They're under a statutory duty to review all of the housing stock in their area for the purposes of the HHSRS and haven't. They're under a statutory duty to inspect every single property they've licensed within 5 years, and they haven't. And that's a consistent problem across larger licensing schemes.
And it's not just capacity. It's confidence in the legislation. It's awareness. It's basic awareness of what powers local authorities do have, and the capacity, I think, gets diverted towards the wrong things.
Yeah. What about Scotland? In Scotland, the position is a very different regime. Would that work instead if that was introduced throughout England?
The Scottish regime is radically different, because that was a landlord registration, not licensing scheme, and initially started as a landlord registration scheme and then had to be revised because they realised they couldn't actually take away anyone's registrations. The second sort of point to bear in mind is when that scheme was created, the Scottish government discovered they had 10 times as many landlords as they believed they had. So they weren't just a power of 2 out, they were a full power of 10 out. So these schemes tend to find unexpected sort of problems. So in a sense, even today, after changes, the Scottish scheme is not the same, because it doesn't have an underlying code of practice, it doesn't have a set of standards, it's not a property inspection scheme, it's an individual inspection scheme. I would suspect a more accurate potential connected scheme is the one that's just been introduced in Wales under Rent Smart Wales, which is more directed and has better powers to reject people. But even there, the Welsh Government has only just about reached issuing licences to 2/3 of the applicants. So I think the problem with these big schemes is that superficially they seem like an excellent idea. But when you actually have to sit down and build a scheme to licence and register that number of people, and more to the point, of course, it's not registering the people, because the people who come forward aren't really the people you're remotely interested in to begin with. It's the people who won't come forward. It's when you have to build that scheme to register those people efficiently, make decisions about them legally in a reasonable manner, and then find the people who never came forward in the first place that things start to become very difficult.
Right, well, here's your opportunity now. Given that you have been quite critical of the schemes, what schemes would you like to see introduced? What would be the ideal way of ensuring that we get the property improvements that we want to see out of such schemes? At the same time, we don't get we try and drive out the bad landlords that exist. At the same time, getting tenants decent living conditions, which I think every landlord would prefer to offer, rather than getting to the problems that currently exist and the ways that have been tried already.
Well, banning orders are, of course, due to finally appear in April, though that's a long overdue improvement to ban. And I detest the word rogue landlord. They're criminal landlords, so if you don't mind, I'll use criminal landlords. I want criminals removed from the sector. Banning people effectively, if it is done, is a big step towards changing the dynamic, potentially. The RLA has proposed a scheme, and I'd say this to some extent because I know it's not entirely supported, but we've proposed a scheme whereby the private sector does more of the work, in the same sense as the tenancy deposit schemes are in fact private sector schemes, albeit by contract with the departments. We think that a similar thing could be done in terms of licensing schemes. So local authorities can have licensing schemes, but landlords would join what we call a co-accreditation scheme that was run by the private sector, which provided alternative dispute resolution, was responsible for making sure tenants knew about their rights and knew about who their landlord was, would provide first port of call dispute resolution just in the same way as tenancy deposit schemes do, and then would leave local authorities to enforce against the worst landlords. So local authorities would still gain money from a much lower licensing fee. Landlords would actually pay a lower fee overall, because a lot of the problems with all this is all the paperwork that's generated. And it's a cottage industry, really. If you think about it, you're talking about 30 different local authorities in London, each of whom have got their own separate licensing scheme. And if I own 2 properties in 2 different boroughs, which is fairly likely if you're a multiple landlord in London, I've got to do the whole thing twice. So it would be much better to have a single national front point scheme that landlords could join that provided potentially other advantages, not dissimilar to a landlord association, but would provide them with other advice and support.
It sounds almost as if you want everyone to become a member of your
trade
body.
What a superb idea.
Which you would offer a wonderful service.
Well, we refer to it as an education body, I think, rather than a trade body. Yes, quite. But we will refer to it as an education body.
But we could have competition.
No, but they should be
competing.
but independent from the current representation. Well, they must be independent and set up in the same way as the deposit schemes are as not-for-profit companies, with dedicated purpose to providing this. But the point being that a lot of the paperwork could be done more efficiently if it was done on a larger scale by an organisation that was dedicated towards doing it. And the private sector is quite good at doing that kind of stuff, doing admin and doing computerised admin. It's something it does fairly well and does all the time across lots of organisations. If I could insure cars all over the country, it shouldn't be desperately hard for me to register landlords all over the country.
Given the figures, I can't remember the figures off the top of my head, but a very large proportion of the private rented sector is small sector tenancies, landlords having 1 or 2 properties or whatever. Given those sort of circumstances, what would be the impact on the private rented sector of such a scheme as you suggested?
We think it would be better because the reality is that fees for licences are very high. We would expect licence fees to go down dramatically because a lot of the cost element of that would be taken away, because all the processing cost ends up being most of the cost of a licensing scheme. And that would leave local authorities to concentrate on what they do best. And at the end of the day, EHOs didn't sign up to be EHOs to process paperwork for licensing schemes. They signed up to be EHOs to go and inspect property and to make properties better. So let them do their job and get the private sector do the administration. Then, of course, if you have alternative dispute resolution sitting there for a first port of call, you automatically filter out a segment of the lower level, easy to resolve disputes, and landlords who are prepared to act efficiently. When things are passed to local authorities, that's landlords who have declined to engage with an ADR scheme. And local authorities, instead of doing what they do at the moment, which is sending lots of letters asking people to get involved and to do something, and usually getting fobbed off quite heavily by bad landlords, they can move straight to active enforcement. And the current regime allows them to recover their costs as soon as they move straight to active enforcement.
Okay, given, actually, no, this is not, that's fine.
Okay. You've got a supplementary on this, and then move on to your own question as well. Okay, this.
So you were talking about the fact that that blanket schemes, in your view, don't work. They create a lot of paperwork. But some smaller schemes can address some problems. Have I got that right?
I've not seen evidence.
Right. Okay.
Our view is that smaller targeted schemes, where they're targeted and against specific problems, can be effective.
Right. So are we talking two different kinds of bodies then? You've just been talking about a national registration scheme.
No, I wasn't talking about a national registration scheme. I was talking about a system that overlies the existing system, so that if local authorities want to set up a licensing scheme, then landlords will be grandfathered into that licensing scheme by virtue of being a member of a more national body.
Right. So a very selective licensing scheme then might work with the landlords in that parent body. Is that what you're suggesting?
Yeah.
Right. Okay.
Because the more selective licensing schemes become, the worse the economics become.
Yes.
Yeah. But the worse the economics become, but is there a greater improvement in the aims of the selective scheme?
So yes, because the more selective a scheme becomes, to justify its existence, the more it's got to set out what its aims and objectives are and then satisfy them. The difficulty is that these things aren't pushed enough, but the requirement is, when you set up a select scheme, is you have to set out exactly what the objectives are, how other things are not meeting them, and how the scheme is going to resolve it. The more targeted a scheme becomes, the more obvious those steps are. As soon as a scheme becomes blanket, you're talking about so many different problems, it becomes quite difficult to say, well, these are the ones we're going to tackle in this way, and the focus is lost.
Okay. Does anyone else want to say anything?
Just a very simple point, which I think if a scheme is introduced, I think it should be introduced with a mandatory obligation for evaluation.
Right.
It should be a last resort. There's plenty of other mechanisms for sorting things out.
Okay, well that could take us down a whole different path about what the requirements would be, but I won't go there in the interest of brevity. Yes. Yeah. So, moving on to my next question then. It is about local authorities and the relationship with landlords of different sizes. Do local authorities work well with landlords when trying to resolve problems?
It's highly variable. Depends on the local authority and the landlord. There are some very good examples of landlords working with local authorities. For example, using accreditation to reduce licensing fees, joint landlord, local authority fora, discounts on services, making services available that often aren't available to landlords, like business parking or waste removal, which is a perennial problem. Things like the Leeds rental standard, and another example, Havering had a programme for redevelopment of social housing, trying to encourage private sector landlords to get involved in that process that they wanted to further. So it's variable, depends on, as I said, depends on the authorities.
I think it's even more variable than that, actually. It actually depends on the officer.
Right.
In practice, because of funding problems, you tend to find a lot of practicing EHOs are acting as consultants. There are relatively few in full direct employment with local authorities. And I'm as one of the few lawyers who actually acts for landlords being prosecuted by local authorities, I see the same names again and again and again on prosecution papers.
Right.
Exactly the same names. So you tend to find that consultants move from between different boroughs with taking views with them. Now, some of those consultants are excellent, don't get me wrong. Some of them are moving for other reasons and may not be as high quality, and you tend to find the same sort of problems cropping up as following individuals around.
And does that vary by, there are geographical aspects to that, or is it nationwide that you're noticing that trend?
Well, the vast amount of prosecution activity is in and around London and the Midlands, so not so much, because geographically that's not a huge distance. I'm certainly well aware of it. EHOs who commute from the South East up to the Midlands on a weekly basis to do their jobs, and vice versa.
We find a high degree of variability in both the capacity, attitude and confidence with which local authorities engage with tackling the worst kind of private landlords, and I agree with David's point. That variability is largely contingent upon the individuals, sadly. The same powers exist, the same legislation exists, the same broad licensing arrangements and objectives generally exist, but the teeth with which they're employed with tend to vary monumentally.
So why do you think that is?
Pardon?
Why do you think that is?
Leadership. I think the quality and calibre of the leadership within the local authorities and the critical role that this task has on proper placemaking and on creating genuine neighbourhoods where families who rely on the private rented sector can settle. If you get this right, then obviously it saves you a whole load of money and hassle in a whole host of other areas. You get this wrong, then actually it has catastrophic collateral effects elsewhere. Local authority leaders and chief executives that acknowledge and recognise that will apply themselves to this agenda, whereas those that don't, this tends to be applied in a way which is, in some cases, quite futile.
Okay, thanks. So if I can follow up with that, do local authorities require new powers, more resources, or both to better support landlords and tenants?
A lot of it's to do with training and support. The CLG produced a guidance document actually as an adjunct on tackling bad landlords, and local authorities seized on it. It ended up being the cornerstone of a number of local authorities' policies. So the difficulty is the legislation is complex, and to some extent it's always going to be, because property is complex. But local authorities, because they don't have the resources locally to build those policies, tend to grab whatever they can and just use it. And in areas where CLG has published decent guidance, it's been used effectively. Where that guidance is outdated, and we should bear in mind the HHSRS guidance was supposed to be updated when it was introduced back in 2007 and hasn't been, and the statistics on it are now in some cases 20 years out of date. The quality of activity in relation to poor quality guidance tends to be worse. There's a very direct correlation from what I've seen.
Thank you.
Helen.
The government has said that it intends to bring forward measures to rebalance the relationship between tenants and landlords and ensure tenants have access to effective redress. And we heard earlier in the evidence session some of the evidence around the problems that some tenants experience with making complaints against their landlord and retaliatory evictions. What legislative or policy changes would your organisation support that would give tenants greater power to pursue complaints and protect them from retaliatory evictions?
Should I start?
Go for it.
I do believe the legislation is biased in favour of the landlord. The whole Section 21 legislation is, as a landlord, very easy to work with, actually. We can apply that legislation freely and with absolute confidence, providing we adhere rigidly to the process. Actually, what fundamentally lacks is any critical critique as to why we're applying it. When a tenant has a complaint about a landlord, its ability to actually do anything which has a financial consequence to the landlord in the short term is very limited. You can't stop paying your rent, or otherwise you run the risk of, as you said, a retaliatory eviction. In our view, the whole system and the residents that make up the private rented sector would benefit substantially from a much stronger voice, and I think the proposals for some sort of ombudsman scheme would be something we as a landlord, a responsible landlord, would totally welcome.
We don't tend to think that an ombudsman scheme will be effective because you're trying to compare housing with other types of consumer relationship which just aren't the same. Ombudsmen are limited. They can only award money. That is all they can do. In practice, if my house is in disrepair, it's not about money. I want my house repaired. Ombudsmen don't fix that. And so we would much prefer to see a much more accessible and more effective housing specialist court that tenants could access more easily to resolve those issues. In terms of retaliatory eviction, it's hard to really address it, because powers were introduced that should have resolved retaliatory eviction, but they founder on the fact that the HHSRS isn't enforced. The reality is that local authorities simply don't serve HHSRS enforcement notices. What they often do, in fact, and the only reason we're in this situation is because they haven't enforced the HHSRS in the past. What has consistently happened is a local authority writes to a landlord and says, we're unhappy with the condition of your property, we're going to serve you a formal notice. The landlord evicts all the tenants, says, well, I'm no longer using it as a tenanted property, and the local authority then doesn't serve any formal enforcement notices. But actually they're supposed to. The regime that was set up under the Housing Act 2004 is meant to be occupier agnostic. It's meant to operate whether there's people in the property or not. If a local authority says, I'm going to serve you an enforcement notice, me turning around saying, well, I've evicted the tenants, why bother, isn't meant to be an answer. The answer is, we're going to make you fix the property regardless. If local authorities followed through and had always followed through and said, we want you to fix the property and we don't care what you do, we're still going to make you fix the property, then, in fact, the issue of retaliatory eviction for disrepair almost certainly wouldn't have got as bad as it's got.
Just to add that clearly the objective is to get the appropriate enforcement in place so that property quality does improve and retaliatory evictions don't happen. We do support the redress and ombudsman proposals as they are, but we do have some concerns over how much it might cost.
And just, sorry, final follow-up. The HHSRS is widely regarded to be too complicated to implement and not fit for purpose, particularly in relation to the resources local authorities have to enforce it. So I mean, I just want, it's one thing to say there is a system which hypothetically on paper works fine and that's what we want to see, but it's another question in the cold light of day to look at that system and to actually to acknowledge that perhaps it isn't fit for purpose. And so I just wonder if I could press you on that and the need for reform for a system that the evidence across the board shows quite clearly isn't working.
But it's largely, I would suggest, not working because it's not effectively utilised. The reality is, and I say this from speaking to HOs and training these guys, they don't understand it. And they don't use it effectively. Now, that is partly perhaps because it is complex, and I would agree there are complexity in it, but if the guidance was updated and brought into proper effect, it could be a lot simpler. The problem a lot of the time is EHOs, for example, will go and inspect property against 29 housing hazards and will obsess about one hazard that isn't of great importance, whereas if they restrict themselves to inspecting against 4 or 5 key hazards that really mattered to the occupier, they'd be more likely to actually achieve an end objective. People get lost in the bureaucracy of it because they choose to, they don't have to. There are local authorities who enforce HHSRS extremely effectively. But I see so many cases where... I saw a case recently on the South Coast where a local authority served 22 prohibition orders in respect to property. It was so bad, no one could live there at all. And they were threatened with appeal in the tribunal and they withdrew all of them. Now either the property was so bad no one should be living there, in which case they should carry it through, or there was nothing wrong with it in the first place. So I think the problem is that there's a lack of understanding of the scheme. I don't think it's entirely the fault of the system. No, I'm sorry, I don't agree.
Thank you.
I'm actually going to move on now to the draft bill that's and that's one or two questions about that. There's a concern been expressed that if tenants aren't charged fees, that the fees to landlords will go up, and the landlords will then find a way of passing the fees on to tenants. Is that your feeling about what will happen with the bill?
If you're asking for loopholes in legislation, then yes, there are vast loopholes in legislation, but it's a draft bill. I mean, the first point I would make is that the CLG said they wouldn't allow the situation that has occurred in Scotland to happen, which is where all fees are post-loaded. Fees are still charged in Scotland. I don't know why people think they aren't. They're just post-loaded. So tenants don't pay for check-ins, but they do pay for check-outs. If you want to get a reference for your next property in Scotland, you can expect to pay for it from your existing agent. So I expect many people will do the same thing here. There are other... Mr. Wilson-Craw raised one particular current error in Schedule 1, and it's clearly a mistake, where it says that you can't charge a higher rental in the first month. Then it goes on to say, but you can if it's in the tenancy agreement. Well, obviously, if I'm going to charge a higher rental in the first month, it's going to be in my tenancy agreement, because why would it not be? So I think there are some mistakes in it. I mean, the other point to bear in mind is that you're trying to treat the whole PRS as if it's the same. I have agents who get 5% of their turnover out of fees. I have agent clients who get 30% of their turnover from fees. Now, if you take 30% of your turnover from fees and fees are banned, you've got two choices, and one of them's going out of business. So that's probably not a realistic choice. The other one is to pass that cost to somebody else or find a way to defeat the system. And most of those agents are outside London as well. So this becomes very dangerously London-centric. Agents in London don't need fees as much because they get more money off commission because rents are higher and their costs are low, which seems counterintuitive because their businesses cost more to situate in. But if I want to view 5 properties in Kensington, I can do it in an hour and a half on foot. If I want to view 5 properties in Wiltshire, it's car time and it's going to take me a day. So the business economics don't stack up the same. And fees are employed in different ways around the country to deal with different issues. And banning all of them won't change that underlying economic structure. So the money's got to come from somewhere. And it will come from landlords, or it will come from loopholing in the bill. And you'll end up with both, realistically, because it's almost impossible to write a piece of legislation that doesn't have a loophole in it, as I'm sure most of you have noticed over the years, one way or another, because the stuff is always getting amended. It's the reality of it.
I'd just say that clearly there are some real costs that are incurred by somewhere in the chain at some point, whether it's referencing or whatever, and those are not going to go away. They'll still be there. Banning upfront fees means that they'll probably pop up somewhere else, or some people will go out of business. And there was talk earlier about increased competition as a result of this bill. It could lead to reduced competition in letting agents in certain markets. It could also reduce the quality of service that people get from their agents. And of course, it could lead to increased rents. And if you increase rents to cover the cost of what was previously charged as an upfront fee, and your tenant stays for more than 6 months, which of course we all seem to want to do, including landlords incidentally, that means that overall those tenants are going to be paying more money than they were before, albeit time shifted.
We banned fees some time ago for 2 reasons. One, it's good marketing, good competitive advantage, but the other was in anticipation of the proposed legislation. And I'll say with candour that the very first question my finance director asked me is, could we put the rents up now? So the truth is, I think the reality, and we didn't, but we're not necessarily like everybody else. I think it's wrong to assume that the cost associated with the tenant procurement, vetting and selection process won't be borne by the process. That those costs will still exist, and consequently, I think those costs will ultimately be borne by higher rents. The truth of it is relatively. If you're a letting agent outside of high value rental markets, your income model will rely quite importantly upon your fee structure. And if your rental commission is a percentage of a small number, then clearly you're going to be increasingly reliant on fees. So I think it's wrong to assume that there won't be any collateral damage as a result of the proposed fee structure. And I think part of that collateral damage will be inflation on rents.
We've heard that actually many tenants would prefer to pay a bit more over a period of time than have to find extra up front, which often is a real challenge for them.
Yeah, it doesn't necessarily, because rent scope doesn't necessarily mean it's fundamentally a bad thing, because actually you've heard today the cost being borne by somebody just moving into a property can run into several thousand of pounds, which is difficult to find at that point in your life. So actually, the fact that there is some inflationary effects may not necessarily be fundamentally a bad thing, but it's wrong to assume that they won't exist.
Do you think that many landlords will decide that managing agents in future are not for them, or will simply manage the properties themselves? Would that be a concern?
Some of our members have said that's a significant percentage of our members have suggested that's where they will go if they need to save money or if agent fees rise. And we think it's likely that agents' commissions will have to rise in some areas as a result. And we are concerned about that because, yes, some self-managing landlords are very good, some are not. And it's really hard to predict up front which ones will be good. But by definition, landlords who are using agents did so for a reason. They didn't just do it because they felt like it, and they probably don't have the expertise to take on those properties themselves, or may not be suitably situated to do so.
Fundamentally, yeah, given the landlord actually has the contract with the managing and letting agent, and they choose who that's going to be, shouldn't they be the ones who pay, rather than the tenant who's got no choice at all over that arrangement?
But if that was the basis, then you already get quite a lot of agents who claim to have 0% commission. Agents who have 0% commission make all of their money right now on fees. So the money always comes back from something, or they make it from sucking their teeth every time something's broken in the property and putting in a new boiler. So the reality is that yes, there will be some competition, but if agents cut their commission, they will have to make the money in some areas from somewhere else, and some of that will come, for example, from commission deals on Sky TV or broadband, which will or utilities, all of which are being pushed out into the market, which will ultimately come back to tenants. They will always end up having to pay the net money because either profits go down within the sector somewhere, and in some areas there isn't very much profit to go down, or more money has to come into it from the bottom end.
Finally, from me, I'll pass over to Liz. There's been no full impact assessment of the legislation. Are you concerned about that?
Well, yes. Everything we've said would suggest that there needs to be one to make sure that we don't have any perverse impacts from the legislation. So, yes.
Liz?
Yes, well, you've covered some of my questions, really. It was about those loopholes and unintended consequences, and we talked quite a lot about the financial bit. Are there any other areas that you would like to mention?
I think there is there's one point here around the deposit, the tenancy deposit, and I'm no expert at reading these documents, so apologies if this is wrong or misplaced. But as an organisation, we are very mindful of the fact that actually financing a deposit and then the rent and the moving costs and everything else associated with the move can be particularly expensive for a low to middle income household. And one of the things we're exploring is whether or not we can exchange the concept of a deposit per se for an insurance policy. And I wonder whether or not that's captured or not by the proposed legislation. And then the other thing was around the actual deposit being capped at 6 weeks. We as a landlord, we have a wide variety of tenants. And actually, you might think this is a small, but it is actually quite an important point. Tenants who tend to have pets often struggle to get properties in the private rented sector because their landlords have a zero pet policy. We as a landlord are happy to take tenants with pets, but often pets cause quite a lot of damage in a property, and actually capping a deposit at 6 weeks rent may not necessarily in an area where the rent isn't particularly high, say £400 to £500 a month, could necessarily cover the cost of, say, recarpeting a house after a tenant's moved out.
And equally, we've heard that there is some concern from tenants about it being as high as 6 weeks.
Yep, we've heard that.
Yeah.
But the current industry standard is about 6 weeks, because if you make it a month, if the tenant doesn't pay the last month's rent, which does happen too often, then there's no money available to fix any damage to the property. I mean, our view on this bill is it's almost certainly not a particularly effective use of parliamentary time. We would much prefer something to be done about the deposit situation. The problem is the reason tenants don't pay the last month's rent is they need to have a new deposit, an extra second deposit, because one of them's still tied up for the next property and the first month's rent. We think the time's now come to convert the existing tenancy deposit schemes around get them to hold tenants' deposits for tenants instead of for landlords, and to provide a guarantee to landlords that they're holding that money, and then to have a small insurance scheme that covers the transition period when there's potentially a deduction from one deposit, but when you need another deposit as tenants move properties, which would probably be funded by the interest on the deposits you were holding, and then continue to operate the ADR to try and get rid of the issue of two deposits. The fact is, a deposit's much more than the average fees. And some of the fees are actually because of the deposit in the first place, because they're actually paying deposit schemes, insurance fees and things like that. So if we were to look more at the deposit issue, I think this bill could actually deal with that far better, and also deal with problems like non-payment of the last month's rent because I need the money for the next deposit and things like that.
I think there's a de facto cap anyway at 2 months, because anything above that ends up being a premium on the lease and gives tenants certain additional rights which landlords would tend not to want. There are also market forces which put a limit on it. I think the point that David made about flexibility is important as well. Landlords deal with a large range of different potential tenants, and some of them are much higher risk. A lot of the deposit, well, in fact all of the deposit judgment and the referencing is around risk management. Pets in particular are a case where landlords tend to ask for increased deposits because there's a much higher risk of damage to the property. The other point is deposit figures, as far as we can see, have barely changed since 2011, and they're at 4.9 weeks. So actually capping the deposit may be solving a problem that doesn't exist.
Right. Okay, so can I ask you then, I mean, I think there's a lot more questions we could ask if we had time, but can I ask you then about default fees more widely? And, is there a risk that these become backdoor fees for landlords looking to increase their
That's quite well drafted in this area. It says quite clearly that the default fee is where the tenant's in breach of a term of the tenancy. That doesn't allow you to manufacture a random term, because you've still got to be in default of it, and it's got to be reasonable, and that's covered by existing legislation. You should also bear in mind that default fees give contractual certainty, because if I simply say you've got to pay the cost of replacing the keys, that could be anything from a £5 to £500, depending on how much effort I have to go to get replacement keys and what they are. If I fix contractually that it'll be £25, then the tenant knows up front what their cost is going to be from a default. So there's an element in which default fees are a well-used device across a whole range of contracts, both in the consumer and commercial spaces, precisely because they give contractual certainty. And there's already a substantial amount of case law, mostly around parking charges, in terms of what an excessive default fee is. So if I want to create a default fee of £500 for losing your keys, I'm not going to get it. And there's clear court authority that I won't get it, and it won't be enforced by deposit schemes either. So I'm not sure that default fees are the biggest problem in the bill.
I think it's a complex area. We heard a different view from the two individuals earlier. We have to bear in mind that the fact that the vast majority of citizens living in rented houses are not necessarily highly financially or legally literate, and as a consequence of an industry which is not known for being the most effective at staying on a moral high ground, that actually the existence of potential for default fees could be used perversely. But equally, in contracts every day, default fees exist. My own personal view is providing those default issues are very, very clearly defined and ring-fenced, then they ought not to be a major problem.
So the question is one of definition.
Absolutely, yeah.
And in your view, Mr. David Smith, as opposed to David Smith, you think that it's sufficiently well drafted already, is that right?
I think the default fee definition is good. That's one of the bits that is quite clearly and well drafted from the bill. Okay. There are other things that are not so well.
And as you've heard earlier, others have a different view about it.
I completely accept that.
Okay.
Thank you all very much indeed for coming to give evidence this afternoon. Thank you very much. Order, that brings us to the end of public proceedings for today.
Proceeding has ended.